The pen was still in my hand when my brother's wife started laughing. Not the polite kind, the kind that comes out when someone has been holding it in for a long time and finally gets permission to let it go. She grabbed my brother's arm with both hands and said something into his ear, and he smiled the way he smiles when a deal closes, tight at the corners, not reaching his eyes. I was standing at the conference table of a downtown Portland title company, my signature still wet on 4 pages of transfer documents, and the two of them were already walking toward the elevator like the room had stopped being useful. I didn't call after them. I had somewhere to be. Let me back up, because what happened in that lobby makes a lot more sense once you understand what the previous 16 months had taken from me. My father ran a small commercial property management company for 31 years. Nothing glamorous. A handful of strip mall units in the outer suburbs of Portland, 2 small office buildings near Beaverton, a warehouse lease he'd held since the mid-90s. He built it slowly and carefully, the way people from his generation understood business to work. Reinvest. Don't overextend. Read every contract twice. He had a property manager named Dwight who had worked for him for 19 years and knew where every maintenance record lived. He had a CPA named Susan who prepared his returns with a level of thoroughness that occasionally made auditors visibly grateful. He was not wealthy by any headline measure, but he was solvent and intentional, and he had, over the course of 3 decades, built something that held its shape. The diagnosis was kidney disease first. Manageable, then less manageable, then the kind that starts organizing your calendar around dialysis appointments and medication windows. I found out in October, on a phone call I took in my car in a parking garage because I didn't want my coworkers to hear whatever my face was going to do. I work in contract compliance for a mid-size logistics firm. I review vendor agreements, flag liability exposure, chase down indemnification language in documents that most people sign without reading. I have spent 8 years building the kind of attention to detail that feels invisible until it's suddenly the only thing standing between a company and a very expensive mistake. It is not a glamorous job. It has turned out to be a useful one. My brother Terrence is 3 years older than me. He has a landscaping company that does well in the summers and less well in the winters, and he has a wife named Brooke who manages their finances with an intensity I had always attributed to ambition and later came to understand as something closer to calculation. They live in a house in Lake Oswego that is slightly larger than their income should support, which I know because Terrence told me so himself. 2 Thanksgivings ago, in a tone I mistook for candor, when my father's condition began to worsen, I reorganized my life around his schedule. I drove him to dialysis 3 mornings a week. I managed the medication calendar. I handled the insurance correspondence, which became its own sustained project when his supplemental carrier began denying claims for 2 of his maintenance medications on the grounds that cheaper alternatives existed. I appealed both denials in writing. I won both. I did not tell my father about either appeal because he had enough to track and because winning felt less important than keeping the friction away from him. Terrence came when he could, which was less often than I expected. Brooke came occasionally, usually on Sundays, usually with a specific question about the business's finances that she framed as concern. Are the properties generating enough to cover his care? Has he thought about liquidating the Beaverton building? What happens to the operating accounts if he becomes incapacitated? Who has access? I answered what I could. I noted what I couldn't. About 8 months into my father's decline, the estate conversation started. My father had a trust. He'd put it together 15 years earlier with an attorney in southwest Portland, a careful man named Mr. Aldrich, who had since retired but whose paperwork Dwight had preserved in a fire-rated cabinet in the back office. The trust divided the business and its properties equally between Terrence and me, with a small separate bequest for a niece in Sacramento. Clean, simple, deliberate. Terrence brought up the estate for the first time at a Sunday dinner in March, while my father was resting in the other room. He had a folder. Of course, he had a folder. Inside it were what he described as business valuations and current liability assessments. He explained, with the measured concern of someone who has practiced the tone, that the company was in worse shape than either of us understood. The properties were aging. The Beaverton building had deferred maintenance that the last inspection had flagged. There were vendor contracts coming up for renewal under unfavorable terms. He said he had been talking to a business broker, someone he trusted, and that a joint sale, meaning both shares transferred simultaneously to a single buyer, was the only realistic path to recovering any value before the liabilities compounded. He said he would handle the entire process. I just needed to sign a transfer authorization granting him power to negotiate on behalf of both shares. I said I needed to look at the documents before I made any decisions. He said, of course, take all the time you need. He left the folder. I took it home. I read it that night. And then I read it again the following morning, because the first read had raised enough questions that I wanted to be sure I was reading it correctly. I was reading it correctly. The valuations Terence had provided didn't match the figures in my father's most recent financial statements, which Dwight had forwarded to me 2 months earlier as part of a routine update. The deferred maintenance on the Beaverton building had been addressed in January. I had approved the invoice myself when my father asked me to co-sign a vendor authorization. The liability figure cited a loan balance that, according to the actual lender statements I had access to, had been paid down by 40% over the prior 2 years. The picture Terence was painting was not the picture of my father's actual business. It was a reconstruction of it, a worse version, designed to make me believe the assets were closer to worthless than to valuable. I called Dwight the next day and asked him to pull the current rent rolls and the last 2 years of operating statements. He emailed them within the hour, and I sat with them for most of an evening, and what they showed me was a business that was aging and moderately complicated but was not in distress. The properties were generating consistent income. The occupancy rate across the commercial units was at 83%. The warehouse lease had 2 years remaining at a rate that was below current market, which actually made it an attractive acquisition for the right buyer. What Terence had shown me was not an assessment, it was a script. Over the following 6 weeks, the calls came regularly. Terence, usually in the evenings. Brooke once, on a Tuesday afternoon, using a softer voice than I had previously heard from her, talking about how much stress the whole situation was putting on everyone, and how it would be so much cleaner if we could just get aligned before things got complicated. She used the word complicated 4 times in 12 minutes. I counted. I did not let on what I had found. What I did instead was call my father's original estate attorney through the State Bar's referral service, Mr. Stead. Aldrich had retired, but one of his former associates, a woman named Catherine, had taken over his legacy client files. I made an appointment, drove to her office on a Wednesday, and laid out everything I had. The folder Terence had given me, the actual operating statements from Dwight, the lender documents, my notes from the phone calls. Catherine read through everything quietly. Then she asked me one question. Had I signed anything yet? I had not. She said good. Then she explained something about my father's trust that I had not previously focused on. Mr. Riva, Aldrich, cautious man that he was, had included a provision that was apparently standard in his estate documents for family business situations. Any beneficiary who obtained a transfer of another beneficiary's interest through material misrepresentation, meaning lying about the value or condition of the asset, would forfeit their own claim under the trust. It was there to prevent exactly what Terence was attempting. It had probably never been tested in Mr. Aldrich's practice. It was about to be. Catherine also told me something else. Under Oregon law, a transfer authorization signed under fraudulent inducement, meaning I was lied to about material facts in order to get my signature, could be voided after the fact. The signature wouldn't hold, but the documentation burden would be on me. I would need to show, clearly and specifically, that I had been given false information and that the false information had been the basis for my signing. I said I understood. I bought a small digital voice recorder at an electronic shop on Burnside that same afternoon. I tested it twice before I left the parking lot. Then I called Terence and told him I had reviewed everything, and I had some final questions before I could commit. And could the 3 of us, me, him, and Brooke, meet somewhere and just talk it through? He said absolutely. He suggested a restaurant in the Pearl District, I suggested one in Northwest Portland, quieter, booths with high backs. He said fine. We met on a Thursday evening. I had water. They had wine. I had the recorder in the interior pocket of my jacket running. I asked with a carefully practiced neutrality what the realistic outcome would be if I chose to retain my share and attempt to manage the business independently after my father's death. What would the tax exposure look like? Whether there was any realistic path to the business continuing under split ownership. What followed was instructive. Terence told me, with specificity and with a confidence that suggested he had said the same thing to Amir several times, that the business would be unmanageable under split ownership, that the liabilities I didn't know about would surface within 6 months of my father's death, that the vendors and tenants would walk when they saw instability in the ownership structure, and that if I forced a partition sale instead of a cooperative transfer, I would end up with a legal fight that would eat up whatever value remained. He named figures. He named timelines. He described consequences with the fluency of someone who had prepared them in advance. None of the specific figures he named were accurate. I knew this because I had spent 3 weeks with the actual documents. Brooke added that their broker had a buyer lined up who would walk if the deal structure changed, that the window was closing, that she and Terence had already committed to obligations on their end, based on the assumption that this would close, that I was, and I am quoting this accurately, creating a problem that didn't exist before I started asking questions. I thanked them for their time. I said I needed 48 hours to think. They said, of course. Take the time. Just don't wait too long. I drove home and sent the audio file to Catherine that night. She called me the following morning and said the recording was clear. She said we needed to have a longer conversation about next steps. I said I agreed. What happened next was not dramatic from the outside. Catherine filed a notice with the court indicating that a beneficiary in a pending estate matter had obtained a recorded admission of material misrepresentation in connection with an attempted transfer of trust assets. She attached a transcript. She attached the audio. She attached the operating documents showing the discrepancy between what Terence had represented and what was actually in the records. Then she called me and told me that the title company had been notified and that I should go ahead and sign the transfer documents as scheduled, because the signing itself was now part of the record we needed, and because the underlying claim would render the transfer voidable regardless. I went to the title company on a Thursday afternoon. I signed 4 pages. I watched my brother and his wife walk toward the elevator with the particular body language of people who believe they have closed a chapter. Brooke was laughing. Terence had his hand at the small of her back. The notary asked me if I needed anything before I left, and I said no thank you, and I walked to my car. Terence's phone rang while they were still waiting for the elevator. I know this because the elevator lobby had glass panels and I could see it through the window of the conference room as I gathered my bag. I watched him look at the screen. I watched his expression change in a way that had nothing to do with the celebration he had been having 30 seconds earlier. Brooke leaned in and he turned slightly away from her, and even through the glass I could see the shift in his posture that happens when someone receives information they were not prepared to receive. I did not wait to watch the rest. I had a 4 o'clock with Catherine. The court's ruling came down 9 weeks later. The transfer was voided on the grounds of fraudulent inducement. Terence's own claim under the trust was forfeited under the misrepresentation provision Mr. Aldrich had written 15 years ago and probably never expected to matter. The business broker Terence had referenced, the one with the buyer who was supposedly waiting, was later found to have had a pre-existing arrangement with the prospective buyer that would have resulted in a referral fee paid to Brooks Personal LLC. Catherine forwarded that detail to the Oregon Division of Financial Regulation. I don't know what came of it, and I have not followed up. I want to tell you something about how I felt when the ruling came through, because I think the honest version is more useful than the satisfying one. I did not feel like I had won something. I felt like I had successfully documented a loss that had already happened, the loss of whatever I thought my relationship with my brother was. That relationship was not the same before any of this started. What I had thought was family loyalty was apparently a calculation that had been running in the background for years, waiting for the right set of circumstances to become visible. I had not done anything wrong. I had also not been protected from anything by being right. What I did with the next 6 months, I settled the estate with Catherine's help, working with Dwight to either stabilize or responsibly divest the properties. I kept the warehouse lease because it made financial sense and because I liked the tenant, a family-owned freight brokerage that had been there for 11 years and had never missed a rent payment. I sold the Beaverton building at a price that bore no resemblance to what Terrence had claimed it was worth. I used part of the proceeds to pay off the medical debt I had accumulated during my father's illness. The part insurance hadn't covered, and I hadn't told anyone about. I have not spoken to Terrence or Brooke since the ruling. I blocked both numbers, then deleted them, then realized there was something small and important about not having to scroll past them. I kept Dwight on as a part-time consultant because he knows where everything is, and because my father trusted him and that turned out to be a reliable endorsement. I saw a therapist 4 times. She told me something in the third session that I have thought about more than I expected to. She said that people who take on the work of caregiving sometimes attract a specific kind of exploitation, not because they are naive, but because their availability signals that they won't say no when it costs them something. She said the solution is not to become less available, but to become more precise about what availability means. I am still working out what that means in practice. What I keep returning to is this. I grew up believing that my brother and I wanted the same things for our family. We did not. We wanted the same outcome from the surface and different things underneath, and the difference never surfaced until the circumstances made it unavoidable. I could not have known this earlier. I could not have prevented it. What I could do, and what I did, was make sure that when the moment came, I had done the work required to see it clearly. I want to ask you something genuinely, not as a way to end the story, on a note that sounds like a lesson, but because I think about it still. If someone you grew up trusting started feeding you false information slowly enough that you couldn't see it happening in real time, if the numbers were wrong by small amounts at first, and then by larger amounts, and the story kept shifting just enough to stay plausible, how long would it take you to notice? Not the moment you suspected, but the moment you were certain. And once you were certain, what would you have been willing to document? I think about the version of me that signs in month 2 before I call Dwight, before I ask for the actual rent rolls, before I sit with the lender statements for an evening and let the arithmetic do what arithmetic does. That version exists. She almost was me. The only thing that stood between her and this outcome was the part of my job I had always described at parties as the boring part, the habit of reading past the summary to the source document underneath. My father built his business carefully and slowly. He put language in his trusts that he probably never expected anyone to need. He left things in order. I think about him most clearly in the mornings now, not because I have resolved anything, but because mornings were when I updated the whiteboard with his medication schedule, and the habit of starting the day with attention to what matters has, it turns out, stayed with me. I've thought a lot about what actually stopped Terrence from getting away with it, and the honest answer is uncomfortable because it wasn't luck, and it wasn't some dramatic confrontation where I caught him in a lie and called him out across a dinner table. It was something much quieter than that. It was just the habit of not accepting a summary when the source document was available. I think about that a lot. The habit, I mean, not the outcome. There's a version of cause and effect that people like to tell themselves, that dishonest people always get caught, that the truth surfaces on its own, that justice has some kind of automatic mechanism built into the structure of things. I don't believe that. Terrence came close. If I had signed in month 2, if I had trusted the folder instead of pulling the actual rent rolls, if I had let exhaustion make the decision the way exhaustion very much wanted to, the transfer would have held. I would have had no legal recourse. The recording wouldn't exist. Catherine would have had nothing to work with. The outcome I got was not guaranteed. It was earned incrementally through small, careful decisions made while I was also driving my father to dialysis 3 mornings a week and managing insurance appeals and trying not to fall apart in ways that would worry him. What I keep coming back to is this. Terrence didn't fail because he was dishonest. He failed because I refused to be incurious. Those are different things, and I think people collapse them too easily. Dishonesty exists everywhere. It doesn't always fail. What made the difference here was that I kept asking the next question when I had every reason to stop asking. I also think about Brooke's role in this. She was not a passive participant. The phone call on a Tuesday afternoon, the soft voice, the word complicated used 4 times in 12 minutes. That was deliberate. She was the pressure when Terence was the documentation. They divided the labor. And what strikes me now is that the same skill that made me useful in my job, reading the document behind the summary, tracking the language for what it's trying to avoid saying, also made me useful to myself in that moment. I had been treating those two things as separate. One was my career. One was my life. It turned out they were the same thing. My father put language in his trust 15 years ago that he probably never expected anyone to need. He was a careful man. He prepared for contingencies he hoped would never arrive. I think that is one of the more honest definitions of integrity I have encountered. Not the absence of conflict, but the presence of preparation for when conflict comes anyway. I'm not going to tell you to trust less, because I don't think that's the lesson. I trusted Dwight completely, and that turned out to be exactly right. I trusted Catherine after one meeting, and she earned it. The lesson, if there is one, is more specific. The people who want something from you in a hurry are almost never in a hurry for your benefit. Urgency is not evidence. Paperwork is not truth. Family is not automatically the same thing as safety. What I have now is a warehouse lease, a part-time consultant who knew my father's business better than anyone, and a quiet understanding that the boring part of paying attention is sometimes the only thing standing between you and a version of events you cannot undo.